Roland Mumford with Mumford.law. Okay, so we all know police officers can have something called qualified immunity, that legal shield that can protect them from certain lawsuits. But what about their four-legged partners? Yep, I'm asking the question you didn't know you needed answered. Do police dogs have qualified immunity? Qualified immunity is a legal doctrine in the United States that can protect government officials, including police officers, from being sued personally for constitutional violations, unless they violated clearly established law. It's controversial, complicated, and sometimes it sounds like something out of a legal drum. Here's the twist. Under the law, dogs are not government officials. They're property of the department. So no, a dog doesn't personally get qualified immunity. You can't sue a dog in court. The case would be against the handler, the police department, or the city. But the effect is kind of the same here. Because if the handler who is protected by qualified immunity, that shield extends to actions carried out through the dog. But the effect is kind of the same. Because if the handler is protected by qualified immunity, that shield extends to actions carried out through the dog. There have been lawsuits where people claim police dogs used excessive force. For example, biting someone who had already surrendered. Courts don't say, well, let's see if the dogs get immunity. Instead, they ask, did the officer controlling the dog violate clearly established rights? If the answer is no, the handler and the department are off the hook, and the dog by extension too. Here's a video recently of a news report where a particular bystander who was participating in watching a funeral procession, actually of a police officer that had passed away, the canine jumps out of the vehicle and attacks this young man walking by. And let's see what happens in this report.
Well, caught on camera, a Suffolk police canine biting a man outside the funeral of the NYPD detective killed in that Manhattan mass shooting. News 12's Cecilia Dowd has the story and a warning. Some of the video is hard to watch.
It happened in an instant. A Suffolk County police canine lunging and biting the back of a man who'd been standing on the sidewalk in the Bronx. The officers were there for the funeral of slain NYPD detective Detained Islam. A witness says moments before the attack, there was a minor crash involving police vehicles.
There was a crunching sound between the two cop cars, the Suffolk County police cars. We saw the dog jump out and basically tried to attack three people and latched onto one. I'm sure that dog freaked out because, I heard the sound and I was like, what is going on? So I could only imagine what a dog was feeling.
This woman, who doesn't want her face shown, said she was walking her newborn when it all happened.
I was freaked out because I have a dog and I didn't know if that dog was going to smell our dog on us and attack us. Fear for my son, myself, my husband. And then when I saw the dog start attacking people, I didn't know where it was going to end up.
In a statement, the Suffolk County Police Department says the door to a police vehicle became ajar and the canine inside escaped biting someone. As you can see in the video, an officer had to put the dog in a chokehold and pulled him off the victim. Police are reviewing the incident. Brett Lawrence is a canine trainer. He has not worked with this dog, but reviewed the video.
The officer putting his arm around the dog's neck, a lot of people are going to say that that was wrong. That's actually right. They have a really good bond. So he was basically hugging his dog and saying, let go, let go.
Lawrence offers one possible explanation for the bite.
It just so happens that that person who got bit, their jacket was baggy enough and loose enough that it looked akin to the training jackets we wear.
Reporting from the Bronx, Cecilia Dowd, News 12.
In plain English, dogs can't be sued. Handlers can be sued, but may have qualified immunity. The doctrine still ends up shielding the dog's actions if the handler is protected, which means your lawsuit is never really against the dog. It's against the people and the policies behind the leash. So no, police dogs don't technically have qualified immunity, but practically speaking, their handler's immunity often covers them. And that's why you'll never see Rex versus State of Florida on a court docket, unless Disney gets involved. Now, we talked about initially in this video whether canines, the dogs, have qualified immunity. And the answer is no. The qualified immunity would extend through the dog to the officer. The canine is essentially an extension of the officer. Now that we've talked about qualified immunity, we need to talk about the excessive force analysis. What is the constitutional law standard to be applied? It's effectively the same, the Graham v. Connor factors. Now, here's a video. It's about 3 years old, but it's a very good case to look at to examine the law that we're going to talk about after this video. This was a lady who apparently and allegedly participated in some shoplifting at a retail store. She escapes. She gets away from the police. They find her in a sort of an area where there's some bushes, some trees. The canine officer releases the dog to seize her. And we'll talk about what constitutes a seizure of a person through the release of a canine by the police officer. And the dog attacked her. The canine officer repeatedly told the dog to stop, to release the dog off of her. This dog attacked her with such ferocity that the skin of her scalp was completely ripped back, that she had to have major surgery to put the scalp and her hair and so forth back together. This was an egregious example of excessive force by the use of a canine. Let's look at this video. Let's talk about the story after the video and through the analysis of the constitutional standard that we discussed a moment ago.
A federal civil rights lawsuit alleging excessive force has been filed against a Brentwood police officer. It stems from a shoplifting incident 2 years ago that ended with the plaintiff being chased down by what the woman's attorney calls a bloodthirsty canine that mauled her. The woman eventually pled guilty and served time for the crime, but she tells Crown 4's Philippe Jagal it shouldn't have resulted in her almost losing her life. We have edited the video you're about to watch, but a warning, what you're about to see is graphic.
Talmika Bates was 24 years old when this happened 2 years ago, and at the time she wasn't clear she would be alive today to tell her story.
Did you feel like that was it for you?
I seen death. I feel like if I wasn't on the phone with her, I would have died. I would have closed my eyes.
Right now! Bates called her mother on the phone while Brentwood police canine Marco sunk his teeth into her skull on February 10th, 2020 in a federal civil rights lawsuit filed on her behalf Tuesday against Marco's handler, Officer Ryan Resentes, and other unnamed officers possibly involved. The complaint seeking money for damages claims, quote, in violation of his training and the law, Officer Ryan Resentes inexplicably sicked Marco on the unsuspecting and unarmed young lady without providing any warning or reasonable opportunity to surrender.
They didn't have to do all that because I was unarmed. It ain't like I robbed somebody.
Instead, the lawsuit states police were responding to reports of 3 young women shoplifting expensive cosmetic items from a store. Talmika admits to being one of them and was found by police in a field nearby, hiding in a bush. That's when her attorney, Adante Pointer, says Marco was commanded to attack. Pointer says the video proves the dog was unhinged, out of control, ignoring Resentes' delayed commands to stop.
Once the dog started attacking and gnawing and clawing and biting at Miss Bates' scalp, the dog was in the throes of a bloodlust.
Hang tight, okay?
I didn't know the dogs was gonna bite me though.
Well, you shouldn't run from the police.
I wasn't driving, I was scared.
Talmika was eventually pulled from the bushes and taken to John Muir Medical Center. Surgeons were able to reattach her scalp. She pled guilty to the shoplifting charge and served time in jail. She is now home in Oakland, where she is back in school. But she says she is still haunted by the mauling. The police department's website shows Officer Resentes and Marco are still out in the field.
Yes, it looks like, to me, what you would imagine and what you've seen in movies and documentaries as it relates to the way in which slave catchers would unleash these vicious animals on black people.
I'm very blessed that I can tell this story and that my mom don't have to be on here trying to explain what happened to me.
Neither the city or police department responded to our direct questions for comment on this story. Philippe Jagal, Crown 4 News.
All right.
These cases fall under the Fourth Amendment, which protects against unreasonable searches and seizures. Now, obviously, here we're talking about a seizure. That's the question, is the use of the dog, especially its bite. The court applies the Graham v. Connor factors. It's an objective reasonableness test. 1, the severity of the crime at issue is the first factor. 2nd, immediate threat to officers and others. And 3rd, active resistance or flight from arrest. Now, obviously, in this particular report, she had fled the officers, but was she an immediate threat to the safety of others? No, she was hiding in some bushes. The severity of the crime, minor misdemeanor, theft, shoplifting, I don't think that commands the use of a canine that we saw in that report. Obviously, we talked about she was fleeing, but was she resisting? She clearly was not resisting. Was the handler giving and controlling commands to release the bite? I believe so. Had they surrendered or were they already restrained? She was in the bushes, she was in the trees. You could say that she had surrendered because they had found her and there was no more flight. Was the bite duration longer than necessary to secure the suspect? That's another factor that would be considered. Let's talk about some examples. If the dog bite lasts for 15 to 20 seconds after a suspect has stopped resisting, that might be seen as unreasonable. But if the suspect was hiding, armed, or fleeing, the bite might be justified as a reasonable use of force. But again, it depends on those three factors that we talked about. Even if the court finds that the dog's use was excessive, the handler in the department might still get qualified immunity unless there is a prior case in the same jurisdiction, with similar facts where a court said that the conduct violated the Constitution. Now, that was an issue that we had yesterday in federal court here in South Georgia on another case that I had. We had oral argument before the federal court. Even if this was excessive, it wasn't clearly established at the time. That's what a defense attorney would argue. They would say that this lady in the bushes having her scalp ripped back by this dog, that she would have to go find another similar case in order to meet that standard that there had been a constitutional violation. And there's three ways that they analyze that. One is they would have to find a similar case. Two, that a statement of law, or either by statute or by a court holding or such other, that said that that was unreasonable and unconstitutional. And third, if it was just so egregious that you would have to deem that a constitutional violation. That lady's scalp being ripped back by a dog might fit that third factor, that was an egregious violation, that it had to be a constitutional violation. Another thing that we have to talk about is consider department policy and training. While not determinative for constitutional law, courts sometimes consider whether the officer followed canine deployment protocols, warnings before release, bite and hold versus bark and hold methods. That's another factor. Failure to follow policy can strengthen a plaintiff's case when she files that lawsuit. And sometimes that can lead to municipal liability claims, what we refer to as a Monell claim. Talking about Monell claims, that's separate from the handler's actions. She could sue the city if there was a pattern of practice of unconstitutional canine deployments, or the department failed to properly train or supervise canine handlers. However, the issue with the department's failure to properly train, it is a high threshold. You would have to show deliberate indifference to the necessity for the training. This avoids the qualified immunity shield for individuals, but it's harder to prove. So the key takeaway from all this, a court doesn't ask, did the dog go too far? It asks whether the officer's decision to deploy and control the dog was objectively reasonable under the Fourth Amendment, and whether the law was clearly established at the time. Thank you very much for the opportunity to present this video to you. Please click like, share, and subscribe, and you have a great day.